Parol evidence rule. As we briefly mentioned in the previous lecture, omitted statements can still form warranties or terms if the appropriate objective intention is shown. This brings up the discussion of Parol evidence rule. Not that this is a parole with an E. Parol without an E means oral. It has nothing to do with the parole with an E. General rule of Parol evidence is derived from the case of Jacob versus Batavia and General Plantation Trust Limited 1924. The purpose of this rule is intended to promote certainty. The general rule derived from Jacob versus Batavia is if the parties have chosen to place their contract in a written document, they cannot provide extrinsic evidence, which is the evidence of the communication between the parties that is not contained in the contract itself. Parties cannot provide extrinsic evidence to add to, vary, or contradict the written document. The document is the sole source of the terms of the contract. Exceptions to this rule are situations where the written document was not intended to cover the whole of the agreement. The rule does not apply, such as in Allen versus Ping, 1838. Parol evidence is admissible to prove terms or a custom which must be implied into the agreement. It may also be admissible to show a misrepresentation, mistake, fraud, or non-esse factum, which means signature by mistake, or to show that a contract has not yet come into operation or has ceased to operate. And Parol evidence may be admitted to prove the existence of a collateral contract. Now let's look more closely into the terms of collateral contract or collateral warranties. This is a way to get around Parol evidence rule that the oral statements cannot be warranties. In D. LaSalle versus Guilford 1901, landlord stated that the drains worked. This statement was not part of the written lease contract. It was held that the statement was a collateral warranty to the written lease. Because the lease was in writing and supposed to constitute the whole contract, the courts used the idea of a collateral warranty to give a remedy in damages for breach of that collateral warranty without interfering with the main written contract. In Shanklin Pier Limited versus Detail Productions Limited 1951, the route of finding a statement as a collateral warranty was used to evade privity rule. Shanklin Pier Limited hired a contractor to paint the pier. They discussed with Detail Productions Limited the suitability of a certain type of paint and were assured that the paint in question would last for 7 years. With this advice in mind, Shanklin Pier Limited went ahead and instructed the contractors to use the recommended paint. The paint was unsatisfactory and started to peel in the first few months after painting. Shanklin Pier claimed for compensation from Detail Production. This case gave rise to the rule that should the third party make a collateral warranty and the formation of the contract depends on that warranty, then a party to the contract is able to sue on the promise despite the fact that it is not made by a party to the contract. The court thought that the pier owners deserved a remedy directly against Detail for the consequences of Detail's false statement. And so it held that the statement was a collateral warranty in a separate side contract between Shanklin Pier and Detail on which the former could sue the latter for breach of warranty. Consideration was provided for this collateral contract by Shanklin, specifying Detail's paint to the decorators. These cases show that when courts are unwilling to allow a statement to be a term of a contract, they may come up with another contract, and the statement may be construed as a term of that other contract.